decline. Like the Hi, welcome everyone to the English show. We are at episode 11, I think.
Is this episode 11?
Is this episode 11? Team, can we confirm? I'm pretty confident.
Can we get an episode blurb?
This is episode 11.
I think
Welcome,
so.
Gil.
How are you?
I'm pretty good.
Yeah, it's the English show. English show is proving to be fun, interesting, and also difficult because Tuesday is a very busy day for us. So
we always arrive frazzled.
Like we're kind of frazzled
show.
to the Tuesday show, and not less prepared though. I think we're prepared. Visa bulletin news, which is good news.
Let's talk about that.
Let's just jam into it. For those people that don't know, if you have an immigrant visa that's other than immediate relative category, you are well versed in a document called the Visa Bulletin. Visa Bulletin, if you guys could pull it up for me. Can we get the Visa Bulletin? Are we going to be able to do this with our dual screen? All right.
There we go.
February bulletin is out.
Mm-hmm.
As far as I understand, Steph, we're still with dates for filing charts for employment base. So this really hasn't changed. By the way, EB4, what did we say? Unavailable
It's
currently?
unavailable again. What happened?
Yeah.
Run the people through what happened and the what is going on there.
I don't know what happened.
Well, no, because remember how you were saying that it was unavailable because it had this congressional hearing, but then Congress made it available again.
I don't think it's available right now.
No, it isn't. Yeah. But in January it was.
That's right. Actually, you're right. It did. Sorry, I have no idea what. I mean, all I could imagine, it's unavailable because so many applications went through.
I will give you that information. It's at the bottom. It's at the bottom. Scroll through.
Let's do it. Let's do it.
Scheduled expiration of employment, fourth religious worker category. So Congress signed on November 12th, 2025, which is why December and January made it available, extends it only through January 30th, 2026.
Oh, hence the reason that there's no visa number available February 1st.
So Congress has to pass something else. So they did a temporary extension. Like the ACA subsidies, they did a very temporary one probably.
Yeah, they have another bill that they need to kick off.
Correct.
Just for the budget. I believe it's towards the end of this month. So don't be surprised if they kind of bankroll that into it. I'm confident that this will become available again throughout the year. And we are still actively pursuing these cases. Just think of it this way. You're not going to be able to adjust your status yet or be able to receive the immigrant visa until, number one, it's available and they have achieved your priority date. But, let me just say it. Diversity lottery.
Nothing.
Nada.
Nothing still, which is crazy. I can't believe that they still haven't set a date. They're saying, basically, remember, diversity lottery is for those individuals who want to literally enroll in the lottery in order to win permanent residency in the United States. That's a program that's available to certain countries, and it typically opens on roughly in October. And roughly in October it opens, and it still hasn't opened because this year they implemented, usually that program is free. They implemented a $1 fee and they haven't been able to figure out how to collect the money.
Okay, now let me be cynical. Stephanie Matza cynical.
Like that.
Let's be Stephanie Matza cynical. Stephanie would say, BS, they could do this in 20 minutes if they felt like it. They chose not to, and they're using that as an excuse to not have it available.
I agree. Wow.
I agree with
your
that.
Cynicism is really.
I agree. It's rubbing off.
It's rubbing off.
It's rubbing off. I do agree with you in that point, 100%.
They don't know how to collect fees.
Believe me,
USCIS doesn't know how to collect fees.
They're really
Department
good
of State doesn't know how to collect fees.
Yeah.
Come on.
They're expert at getting money.
they will get the money.
They'll get the money. Okay. Let's go to good news.
Let's go.
Employment third category.
Yes.
Nice.
EB3.
We got a good move there. I believe it was July something previously.
I'll tell you the exact one.
Let's get the
it was July 2023.
Yeah, nice move. I mean,
Super
August,
nice
September, October, anything before October 1st. So remember, if you're October 1st, you still can't do it. Anything prior to October 1st, you are eligible starting February 1st to file your adjustment status, or very likely you'll start hearing from the NVC to start consular processing on your case. If you've been waiting a while, they should do that. They should be in touch with you, Department of State, rather quickly. I would say typically within 30, 45 days of the visa number becoming available when they'll start that process. So that's very good news. Definitely affects a lot of our clients and our ability to file adjustment of status. EB2 and IW has not moved.
Stayed the same.
But guess what? That
It's
moved
still really good.
super aggressively.
Last month,
we are still of the opinion, if your EB-2NIW is not approved yet, but there's a visa number available, do not file an adjustment of status yet.
And don't do premium either.
And don't do premium. But I really want to do premium.
No. Unless you have a specific reason, okay? Unless you have an age out child, unless like
actually age out child premium messes you up.
Yeah, actually that does. I was about to correct myself on that. Don't do premium even if like I'm saying in the situation of the visa bulletin is available.
That I understand.
And I have an age out child.
Oh, that's a good
when you
point.
would do premium.
That's a good point.
So my priority date was August 2023, August 2024. I'm suddenly able to file adjustment of status and my kid is about to age out. Yeah, yes, maybe consider it. Or maybe just do the concurrent filing. But premium is just not the move right now, not with EB-2NIW.
Really nice I-130s.
F2A is beautiful.
F2A.
It's just trucking along.
LPR spouse, LPR child under the age of 21. Filing, obviously I-130 already has been filed. You have a priority date, January 22nd, 2026. Yep. Amazing. Excuse me, anything prior to the 22nd of January, 2026, people have to wait a very short amount of time, maybe in some cases 30 days to file the adjustment of status. That is very good. I still say that has everything to do with the fact that there's a little bit less immigration right now in total, and that has improved, I think, dramatically. Also, I think this is just my opinion. Less people are going to be applying for U.S. citizenship because they perceive it to be more difficult right now, which really that's not necessarily true. But since they perceive it and they want to petition their, spouse or child, for example, we're going to see that category advance throughout the year with more retrogression.
I think there's going to be more applicants.
I think there's going to be more applicants in that specific category because there's going to be less immediate relative applications because people are not becoming citizens.
Which to that, listen, there's a lot of things going crazy with immigration right now. We can't deny that. But N400 and citizenship, unless you're from one of the blacklisted countries, it's really not having an issue. Yes, it's changed slightly in that you have to answer 12 of 20 questions correct versus 6 of 10, but you were memorizing those answers anyway. Like, you're going to be fine. The N400 is not getting dramatically more difficult. It really hasn't.
For the Instagram crowd, can you look up? You look up all the way. I'm going to look down.
No, why?
And now you're looking for the Instagram, for the vertical. I'm looking. Yeah, there you go. You're looking up. I'm looking down. Look at that.
Is it because you're on top?
Yeah.
I should be the number one information. Because we're also streaming on Instagram.
Should we flip that around?
Yeah, you should definitely flip that around.
We should flip.
I am the top dog here. That's
here. Look, I'm looking up at you. I'm looking up at you.
Okay. You could put Gail on top.
Let's go to some questions.
By the way, yes. So those of you that it's episode 11, people may not be familiar with our format. Our format is we answer questions live. Any immigration questions that you want to throw our way, send it our way. At Beltran Burrito, we focus mostly on business and family-based and investor-based. So very rarely asylum-based. So if you have asylum questions, we might not be able to answer, but ask them anyway. We'll try and figure it out. So let's try and answer some questions. And then after that, our hot topic for today is we're going to be talking about dual intent visas and what that means.
Excellent. Let's jump into the Q&A.
You want to go first?
Yeah, sure. We'll just take it right here. From Instagram, Ruthie. Hi, I just applied for naturalization. I'm Venezuelan and Portuguese. Do you think that will be paused? Yes, Ruthie, I could tell you it is paused. Regardless of the fact that you are dual national, it's great that you're a dual national. That no longer is something they're taking into consideration. They're seeing you as a Venezuelan national, and as a Venezuelan national, there is currently a pause in those cases. That means you could file. You're just gonna have to wait a little bit longer for your interview and hopefully your citizenship. However, I will tell you that I think things are going to be better throughout the year. I think with the changes in Venezuela, we said it, Steph. I think I said it 24 hours after it happened. I said they're going to open up the consulate in Venezuela.
Did you see the videos yesterday?
Yeah, and they're starting.
They had the convoy going into the. I was like about to text you last night.
Yeah,
They had the convoys going into the U.S. embassy in Venezuela.
They're going to get activated again. That embassy.
That was an interesting call on your end.
That's an important piece of information, because if the relationship is good enough to open up a consulate, that tells me that their security concerns are going to be diminished, because they can be in country able, if quote unquote, it's a security
or at least they
issue.
have to say that, right?
Yeah. So they'd be diminished, and by virtue of being able to interview people directly in country. So I would imagine the proclamations start going away for Venezuela.
I would think so.
And I hope so. So I would tell you, Ruthie, if you're eligible to apply, I'm sorry, you already applied, don't worry. It's going to be a time factor. Keep in mind, be careful if your green card's expiring or something like that. Just you want to be on top of those things. But regardless, I think this year you're probably still going to have an interview. It's just going to be longer than the 6 months that they have online currently.
Would you recommend renewing the green card?
I always say renew the green card regardless of the fact that I applied for N400. I'm sticking to I've been saying that for over 20 years. I'm telling you, I'm going to stick to my guns on that. I just researched that recently for somebody else. And I feel validated and
safer route.
Continuing to give that advice. Some people tell you it doesn't matter because you're just applying for U.S. citizenship. Your country was just paused for cases. Let's be real. Let's make sure that we're protected always with the green card.
I think it's better to be conservative.
Yep.
Anabel Salcedo from Instagram. I'm not sure it's really a question. It's just because of the fear of being Venezuelan. This may be tied to Ruth's question, which is yes, basically dual nationality is going to affect the presidential. Proclamations do affect dual nationals.
Absolutely.
Alrighty, I have a super chat from Gabriel Caves. I'm an F1 holder, completed a certificate moving to a master's. Do I need a new visa or just a status extension? Is this valuable with a pending EB2 application? So I'm assuming you entered the United States with an F1. So because you're saying F1 holder, I'm assuming you entered with the visa F1, right? So if you look up your I-94, it likely says D/S duration of status, which means as long as you have a valid I-20 for study or an OPT card, you can remain in the United States without formally filing anything with immigration and without formally requesting a new visa. The next time you travel outside of the US, and if the visa is expired in your passport, you would need to get a new F1 visa issued. But if you're still in the US, your I-94 says DS, you just need a new I-20 from the new school.
Pull up there all the countries that are banned, the 19 countries.
19 country ban.
I just want to go over, is that it? Is this it? Sorry, guys. I'm just looking to see everybody that's on here. Palestinian Authority documents. I just want to be able to several U.S.
What are you looking for specifically?
For Palestine.
Well, Palestine isn't.
It is right here. Authority documents. Mira.
Does it say it?
Yeah.
There it is.
Yeah, it's part of it. Justification or partial, and that's a full suspension, by the way, not a partial. Is that a partial or a full? Let's see. Strength. I'm sorry. Find it.
Full restrictions and entry limitations.
Okay. So
I was surprised. I didn't think they separated it out in the proclamation. I didn't remember seeing that.
Yeah, I hadn't paid attention to it. I was born in Palestine. Hi, Mushahid. I was born in Palestine and hold a Jordanian passport. I'm interested in the NIW. Could the ban affect my petition? Yes. What are my chances? I have an F1. Okay. So you could apply for the EB2 NIW. You're just not going to until, regardless of the fact that you're a dual national, until that ban is suspended, particularly for people born in Palestine. Unfortunately, you're not going to have a result on that case. So you could be of the thought that, it's not a good idea to apply anyways because there's a ban right now. I'm of the opinion actually it's a good idea to apply. You could apply for it. That could be pending. Maybe it's going to be pending. As we've mentioned here before, EB2 NIW right now is like 20 months, 22 months with normal processing. In 22 months, I would expect that that's changed completely, hopefully, and the relationship has changed. And, obviously that's still a very active situation, what's happening over there. So hopefully it's changed enough that they're going to start processing those cases again. Doesn't mean they won't review it. Doesn't mean they won't issue an RFE. They will just not give you a final decision because I'm still seeing RFEs on cases from that are on the country list. They're just saying, hey, by the way, we're sending you the RFE, submit the response, but just understand that this case is likely to be in pause. So I'm still of the opinion that if you qualify, yes, go ahead and proceed. Be very careful traveling outside the U.S. right now. Okay. I would be, do you think he should be coming in and out of the U.S.?
Mm.
I wouldn't. Or definitely.
With Jordanian passport, I'm not that
Or,
stressed.
or I know, but they're just seeing him. They're going to see place of birth. That's my issue. So let's talk about it. Feel free to reach out to us. Contact. Where am I going to put it? Up here.
Which I will
Somewhere?
say,
Contact.
it's going to be somewhere. Which I will say, I have seen at least one. Oh, but Venezuela has a partial ban in comparison to a full ban. So that might be different, because I was going to say, I have seen an I-140 approval for Venezuelan, and just they're not allowing the consular processing aspect ever since the ban went into place. I did see that put into place, but Palestine has the full, and versus Venezuela has the partial. So I take back what I said. Alrighty, let me see. The last time I entered the US with ESTA when I was 18 and overstayed for 2 years. What are my options if I want to apply for a work visa? Can I have a waiver?
Hold on. She changed her name.
She did.
Because I remember her picture.
Her name is Adriana.
For many years, multiple years, seeing her on the Spanish show.
Her name is Adriana.
There you go.
Mm-hmm.
Well, we're like, what are we? We're like sleuths. We're
FBI.
Undercover. Well, not that undercover.
Yeah, you weren't supposed to give up our secrets. It was information we could have kept in our back pocket. You would be a horrible spy.
Probably.
You really don't have options because the overstay happened after the age of 18. Gotta go get a U.S. citizen boyfriend, my friend.
Whoa. Whoa. Get married right away?
I mean, what else are you gonna do?
Huh?
2 years after 18, overstay.
Yeah, put yourself out there.
Got nothing.
You know?
And you leave the United States, you're subject to the 10-year ban.
That wasn't her previous background. This tells me, that wasn't the previous background. I don't know. My memory's pretty solid.
It's exactly what you're thinking.
Oh, okay. So let's go to Eric Vallejo. I'm an F1 student with an approved I-140 EB3 priority date, August 2023. Awesome. I've been in the U.S., so obviously your date's up. I've been in the U.S. for 3 years. Could this be negatively affect what happens if the company declares bankruptcy or sold? Okay, that's a problem, Eric, clearly. But
Erica.
Excuse me,
Erica.
I
know this person.
Okay, sorry, Erica. Erica, you're fine. You could file the I-45 already, which is fantastic. I suggest you file it immediately on February 1st if you can. And my reasoning for that, I'm sorry, you're not other worker, are you? As long as you're not other worker. Okay. So I would file that immediately, because once that I-45 has been pending for 180 days and there's an issue with the employer, you could transfer that case to a new company as long as the I-140 has been approved and 180 days of the I-45 have already passed. Then we could go ahead and file. You file an I-140 supplement J form. You provide the taxes, the job offer, the transfer, and then you're able to transfer employment. Now, if prior to that, the company goes bankrupt, I would say basically it's over.
Now, if 180 days has passed and she could port.
As long as you could port, you're fine.
Does the new company have to do a new process with the Department of Labor?
They are not. No, I say no. Yeah. Were you testing me? Oh.
So she understands the whole implication. The whole implication is, does she have to start from scratch?
Yeah. Sorry, just to be clear, you do not have to file a new labor certification, Erica. Okay.
After 180
the new
days.
company does not, as long as the I-45 has been pending for 180 days. So good news for you. You could start the clock on that 180 days.
As soon as you file.
Hopefully the company, also a lot of companies don't go bankrupt so quickly. If the company is sold, as you mentioned, doesn't concern me so much because there's provisions for that. So successor in interest or whatever, it's possible as long as the company that it's being sold to still wants to take you on. So a little bit more complex, but still doable. Bankruptcy, not doable.
All righty, let's go with Larry Leon. I've spoken to Larry, I think. I'm an F1 visa from Venezuela. The new proclamations and ban affect me to travel outside the U.S. and come back. If the F1 visa is already in your passport, it does not affect your use of the F1 visa, but they are not otorgando. I love that I do this all day in Spanish and then I can't remember how to do it in English. They're not stamping new F1 visas, issuing new visa. You see how I direct translate? They're not issuing new F1 visas to Venezuelan nationals at this time. So if it's already in your passport, you're fine to travel.
If not,
stay in the United States and file a change of status.
User TE. Hi, TPS change of status to F1. If the F1 is denied, does unlawful presence start from November 7th when the TPS ended, or from the F1 denial date? If I leave the US now while still pending, do I accrue unlawful presence? Thanks. I say unlawful presence is accrued upon the denial. If you are obviously TPS 2021 and you had until November 7th, and depending on what your immigration status was prior to that, assuming you had a non-immigrant visa status, and for example, I don't know, not asylum or something like that, it could be different results. I'm saying just with the information you provided there, no, you do not have unlawful presence until the clock starts upon the F1 denial. Okay, I'm pretty convinced that that is very arguable and that is a good point. So as long as you depart within 180 days. Now, as to your question, what happens if I depart during the process? Well, the change of status will be denied automatically, okay, because you departed the United States. But the reason it's going to be denied is because they see you departed the United States and not because you don't qualify or you can't change status from TPS to F1, for example, which is the big problem we're seeing right now. Now, having said that, why is that a good idea if you're going to be leaving anyways in the future and you want to leave now? Because they know that you left and they're not going to put you in immigration proceedings. Okay, that's why that's a good idea, because they're going to see that you left and you're not going to get a notice to appear to go in front of immigration court, which I still believe is going to happen to many people with TPS that they saw they did not leave the United States, regardless of the fact that you filed a case or did not file a case on the appropriate dates. I will tell you something, though. I've seen less NTAs in the last month or so, which has surprised me. Maybe something happened internally there.
Maybe they figured out that all these people were going to the court and being like terminating the LTAs because they all filed things, and they were like, maybe we should check if they have filed something before we issue an NTA.
That's yes. So that's it, user.
Alrighty, let's see. Elias, asylum-based Venezuela. If my EB2 gets approved and I want to apply for an O1 to avoid waiting for the EB2 and IW to become current, is it the same process as the EB2? Do I have to leave the country? So Elias, you currently do not have a status that can be changed. So this goes exactly to what Gil was just talking about, right? You are currently asylum. You do not have a status that can change. If you were TPS, for instance, and your TPS was still active and we were in November 1st, I could change you to an O1, but asylum cannot change status. So if you want to do an O1, you would have to leave the country. Here's my fear. How long have you been with that asylum? If you've been with that asylum for 10 plus years, by leaving the United States, it could be potentially interpreted that you abandoned the asylum. And so all that time you were essentially without presence because you essentially abandoned it, right? So I'm very fearful of you leaving the United States to get an O1 visa issued, and you cannot change to an O1 within the United States. For me, you have to stay in the United States. You have to wait out the decision for the asylum. Once the asylum has a decision, then go ahead and, if anything, God forbid it's denied, then go ahead and go consular and do consular processing in the EB2. But don't do an O1 right now.
I get a ton of pushback on the idea. Like sometimes I don't want people to waste their money or time.
Right.
And you're in some people are just hell bent to do it. As long as you understand the consequences of that, I'm just telling you right now, no, absolutely not. Things change in 6 months. There's a better relationship. Immigrant visas based on EB2 and IW, EB1, EB3 starts again actively being issued at the U.S. consulate abroad for Venezuelans. Then I'm of the opinion, hey, you could try 5 years. So I'm of the opinion you could try it. The likelihood of success is not very high. Okay, not impossible to win it. Okay, as long as you don't have unlawful presence, you have a stance to argue it, which is true. But I just think it's tough. It's such a tough sell to go ahead and tell somebody, hey, we're going to do this, and there may be a chance you never come back to the United States.
And then here's the thing, right? So Bogota is giving us pushback on O1, and we're going to go to dual intent now. Bogota is giving us pushback on O1s, even though O1 is a dual intent visa in regular situations. You imagine a person who has been in the United States 5 years in asylum?
Yeah.
Like they're not going to.
Yeah. I mean, we have successfully gone.
We have
asylum, TPS, 0101 getting issued at the consulate.
Mhm,
Okay, we have
mhm.
done that, and I believe TPS H1B as well at the consulate. But listen, that's when things were a little bit different, like, 6, 8 months ago. How they are right now, I'm very hesitant.
Absolutely. I agree.
Mm. All right, let's get into it.
Wait, there's
Dual,
one more. There's one more. There's one more that's good.
we could come back after the dual intent.
Okay.
Let's
All
go
right.
dual intent.
Okay. This
We're
was
gonna
it was a
go-
good one. Okay.
We're gonna go
All
dual
right.
intent.
Fine.
Dual intent. What's dual intent?
Hello. Dual intent. You want me to do the intro? That's
I could do
crazy.
it. So what's dual intent?
Dual intent. All right. What is dual intent? Essentially, when you enter the United States, your intention on that trip is assessed by a CBP officer. Okay. When you enter the United States, if you're entering with a tourist visa, then you are stating, my intention is to enter as a tourist visa and I plan to return to my home country. That is your intention. When you're entering with a green card, then you are entering and saying, my intention is to be a permanent resident of the United States. Here is my green card. Now, this is relevant when you are applying for things that include both the intent to permanently remain in the United States or the intent to leave the United States. For instance, when you're applying for a tourist visa, you always have to show that you plan to return to your home country. And that's why you have to provide evidence of ties to your home country, such as bank statements, properties, and these things. So this becomes relevant because when you're applying to, let's say you have the intention and you have shown that you just want to be here in a temporary format, but you also want to show that you want to be here permanently in the United States, you want to make sure that your intentions don't crash and contradict, because it could be a reason for them to find that you're being fraudulent when you appear yourself for entry to the United States.
So that's great, and that's in the with the idea of when you're entering the US, but generally speaking, also when you're applying for a visa. So you're an EB2 NIW applicant, you're an I-140 applicant already, a company's petitioned for you in the past, you've already demonstrated immigrant intent, you now are going to apply for a tourist visa extension, an F1 visa, an E2 investor visa. There's certain, a TN visa if you're Mexican or Canadian and you're, you're part of the NAFTA treaty and you have job offers in the United States. I would say that there's dual intent visas, medium intent, and definitely no, you cannot have an intent to immigrate. I put in there B2 extension, B2, F1s generally at the consulate. At the consulate. I put in there E2 visas at the consulate.
Agree.
Very different my strategy in the US than outside the US. This is a consulate. I'm talking at the consulate, okay? TN visas at the point of entry or consulate. If you've already demonstrated to have immigrant intent, they ask you on the consular forms, are you the beneficiary of an immigrant process, immigrant petition? That you're like, well, I'm not, my husband is. Guess what? You are, okay? And you need to put that information. I don't have a problem that a visa is denied because you told the truth on immigrant intent. The issue becomes if it's denied based on, leaving a material fact out of the application.
Yeah, so it's when you're applying for immigration benefits, you have to cognizantly think, what have I shown my true colors, my true intention to be previously? Because that could affect your current petition. So that's going to determine the order in which we apply for things. That's going to determine the location in which we apply and where we apply for things. That's the question of intent. It essentially is going to make that determination for you of how and when to apply for things, so you're never contradicting yourself in front of immigration. I feel like an easier way to do it is with examples, right?
Yeah.
So, okay. So
dual intent.
An example of dual intent?
Of dual intent.
Okay.
Yeah.
Perfect. So I have applied for an EB1 or an EB2 NIW. And that is something that's showing, hey, immigration, I want to be a permanent resident of the United States. After that, because EB2 is waiting so long, I apply for an O1 visa. O1 visa is permitted because O1 visa falls into dual intent, and O1 visa it allows you by law to be able to say, hey, I plan to remain in the United States. I do not have to show ties to my home country. I do not have to show that I plan to return to my home country with little asterisks here and there. But essentially, I can do that. Yeah. Now, let's take that exact example, but do it alternatively. I applied for an EB to an IW. I want to remain, but I'm just waiting on my visa bulletin in order to go to the United States. If I apply for an E2 investor visa now, which is not a dual intent visa, they're going to tell you no, because they're going to say, as an E2, you have to show that you're going to return to your home country. But you, on this other hand, said that you're not.
You literally have to sign a piece of paper for the E2 that says, I intend to return to my home country.
Right. And that can't be the case if you filed for an EB-209W and have an EB-209W approved. So what does that tell you? If you want to do an investment and then an EB-209W, that's the order in which you have to do it. You have to do first your E2 investment and then your EB-209W.
Yeah, a couple more just really known dual intent visas are always H-1B, L1 visas. So L1 visas, H-1B, that's the traditional dual intent. Obviously, O1 is kind of clumped in there as well. P1 is not dual intent.
I think it is, no?
For athletes. Excuse me, I believe maybe for athletes, but not for P1S. It was like, take a look at that, dual intent on Ps. But definitely H's and L intercompany transfer. After you've been on the U.S. payroll for 1 year on your L1, you're eligible to apply. The company may petition you for an I-140. Interestingly enough, you don't even really have to demonstrate that. This is a GIL rule. I think it's better if you're on the payroll for at least 1 year, technically. Okay. After that time, we go ahead and file what's called EB-1C3s, I-140s for the company. That's the L1 jumping to a green card, usually, or we could go L1 to perm. H-1B, perm, almost always is going to be the method, or we go H-1B, EB-209W, or even H-1B, EB-1. O1, generally, I'm going O1, EB-1, O1, EB-209W green cards. That's kind of how kind of the menu of options for dual intent. So regardless of the fact that you've already applied for a green card, you are eligible to obtain those visas and renew those visas during the green card process. What's up?
P1B music group is dual intent. P1A athlete is not dual intent.
Oh, I knew it was something.
Yeah.
Hey,
and P1S, that's actually another one, right? So support of both O1 and P1, which is O2 and P1S, those are definitely not dual intent.
Hey, come on.
Yeah.
The memory's good. It's good.
It's okay.
It's the creatine.
All right. It's Taraboom. Find it on Amazon.
It's the creatine. Not yet. I'm not hitting them with it yet. So that's dual intent. Obviously, a lot of things to consider there. I think just like kind of when you're doing, I don't know how many moms and dads we got out there, but order of operation for math homework with the kids.
Yeah.
Order of operation for math homework. Do your temporary visa first if you can.
Right.
Which has the non-immigrant intent, then jump into an immigrant intent. If you have the immigrant intent first, the reality is you've kind of shut the door on other options for yourself. Okay.
That, by the way, we keep talking about this in the employment context. This also applies to the family context.
Yes.
So it is, if let's say you have filed an I-130 for your spouse and you're like, you know what, I want to do adjustment of status, but your spouse does not have a B1 visa or B2 tourist visa, you can't go and apply for the B2 tourist visa now because they're going to say, wait a minute, you have an I-130 pending. You want to be there permanently. I'm not going to give you the tourist visa. It happened to me today.
You could try, but it's not going to work.
You could try. And I had one denied literally today in El Salvador. I was like, give it a try. Let's see what they say. And they were like, absolutely not.
Man, El Salvador, huh?
Yeah.
I love their prison system.
What is wrong with you?
No?
You can't say that on. Did you watch the CBS News special?
Yeah.
Crazy.
Love CBS.
Anyway. Why are we here, family?
Let's go to the questions.
You want to? That's it? You're done on dual intent?
Hey, dual intent. Live it, breathe it, be it. Next.
Dual intent is important. That's all we're going to say?
Yeah.
Okay, wait. Hold on. This is a good question related to dual intent. Please.
Emma, can family members, spouse, and children accompany me on a dual intent visa, and do they also get dual intent benefits? Yes, they do. Spouse and children under the age of 21. Just depends kind of the visa we're talking about there, Emma. If we're talking more of a work visa, you have to keep in mind maybe your spouse is not able to work. Your children will always be able to attend school. Definitely, that's not an issue on a derivative beneficiary visa. Yes, the idea is always, I would say with immigration, is to keep the family together. So you're going to have all types of visa categories, regardless of the fact if it's dual intent or not. You're going to have the ability, generally speaking, to have a derivative visa so your family could be here together. The issue will always become if there's work permits attached to it, does that actually lead to a green card or not in the future? I know you want to focus on dual intent ones, which is wise if you can, and if you're eligible for it. But yes, your family is included.
Emma does a follow-up question, which is, what alternative exists if I don't qualify for a dual intent visa, but I still want to explore permanent U.S. residency options? So Emma, my first recommendation would be get a tourist visa. It's useful for every single person to have a tourist visa because, assuming that you can and you're not affected by presidential proclamations and the such, because if I ever wanted to do an adjustment of status in the future, I could. So first step is before you do any permanent residency, do a tourist visa application, get your tourist visa, and then apply straight for permanent residency. Forget the dual intent visas. Don't do them for now. Maybe later in the future, you'll be eligible, but just go for it. Do stage 1 of an EB, for instance, of an employment-based immigrant visa application. And then using your tourist visa that you already got, you can enter the United States and do an adjustment of status.
Or if you don't have that anyways, just go straight for the green card. If the green card's there, it's, a lot of people decide for many reasons. One, it's not easy not to have work permit in the United States. It's expensive. And a lot of people have this idea of, I'll come to the US and I'll figure it out. That's really bad idea.
Expensive.
It's a very expensive proposition. So I'm of the opinion that, just have a consultation with us, Emma. We'd be happy to help you, okay?
You know what's worth, I think, talking about here? Why don't you discuss how you would handle F1 differently, how F1 is maybe medium intent when you're in the US?
Yeah, good call. I do this frequently, and it generally works.
Well, because they changed it.
Yeah. So they did change it. So previously, F1 was not dual intent at all. Here in the US, they have, even though I haven't seen, I have a feeling this might be repealed in the future.
You think?
I think it may. Or there.
I think if they were going to do it, they would have done it already.
You think?
Mm-hmm.
I don't know. I've lost a little faith. Okay. So to say the least. So let's say let's say you're already the beneficiary of an EB-2NIW. You enter the US as a tourist, and I'll file a change of status for you to an F1. They're saying that as long as your initial intention was to enter as a B2, which is non-immigrant in nature, regardless of the fact that that I-140 had already previously been filed. A good argument I have there is that chances are that I-140 was filed consular. Clearly, your intent was to do it through the U.S. consulate. You find yourself now after 90 days as a tourist in the U.S. and you've decided to file an F1 change of status petition. I am doing those. I used to always do them, Stephanie, and I really never had an issue, even for my clients to have I-130s and I-140s pending. Now, being a little bit more conservative, if we could, elect to do a different category of visa, it's good. But yes, F1 is that weird in-between one. If it's in the US, it's fine. It's at the consulate. That'll highly likely to be denied.
Larry does a follow-up question. Oh, excuse me. Were we done with dual intent?
Sorry. I've been done 2 segments ago.
I'm sorry. I'm so sorry. All right. I'm going to jump back to the questions then. Larry did a follow-up question is, can I marry my Venezuelan girlfriend and have her apply for an F2 visa with this ban in place? Larry, F2 is also subject to the presidential proclamation. They are not issuing F2s for Venezuelans.
But can they? Is he outside the U.S. or inside the U.S.?
He is inside the U.S.
So if she's here and she's in lawful non-immigrant status?
He said that earlier.
Oh, I'm sorry. She's not here.
She's not here. She's abroad.
We got to get her here.
But she can't get a tourist visa issued. Because they are not giving it to Venezuelans. She can't get an F2 issued.
I'm sorry. If she doesn't, then there's unfortunately nothing to do.
Maybe do like we said, no. Yeah. Well, maybe we do like an 01 and then she gets an 03.
Oh, yeah. I mean, a different visa.
Different types of visa. Because the ones that are positive are B, F, J, and M. B, F, J, and M. Yes.
Angel, I'm speaking English to you. Hello, attorneys. Hi. My 01 expires October 2027. How much time in anticipation should I file the 01 extension? Keep in mind, Angel, that currently, right now, non-premium 01s are taking a long time. If you're going to file premium, really, June 2027, May 2027, I'd crank it up a little bit. If you want to file the case, non-premium processing, you literally have to start this year. I would be
save those 3,000, but premium fee is going up.
Oh, we didn't talk about it. It's going up not too much, but now we could basically call it $3,000. $2,965. So now it's going up $2,965, literally $35 away from $3,000. So we could call it $3,000. I've been calling it $3,000 for a while, but it's $3,000.
No,
it's
really
a lot of money when you think about it. Drop an 01, an 02, a couple people there, and all of a sudden you're dropping a ton of money on a case, So I would say that's the anticipation, always sooner than later. This is an interesting point, Angel. I could apply for an 01 visa up to a year ahead of time. Okay. I don't mean my start date on the visa. So let's just say October 2027, I could apply October 2026 for a start date right after the current one. You could do an extension up to a year in the future. I actually haven't tried it more than a year because I think it's not possible. I'm think it's possible.
Pretty confident you're right there.
I've done up to a year before for an extension before. If you're willing to do premium and kind of pay the money, then it's up to you when you do it. Okay. I would say just like May, June of next year.
I would.
Oh, thank you, Jasper.
Save the $3,000.
Thanks for your email list. I learn a lot from you guys. We have a lot of questions related to time and waiting for USCIS. I understand, Jasper.
Everyone's questions.
Everybody's got questions, man.
Everyone has those questions. I get it.
I got it. I'm an F1, wanted to apply for an 01. A friend and I are making a company. Ooh. Tell me more. How much funding would we need to get 01 approved? Depends. Type of business we're talking about. If it is an assets business, maybe we need a lot of venture capital in there. It's a startup app. If it's a tech company, I would say the money is not as important as the legitimacy of the endeavor.
Agree.
Okay. If it's a real company that you guys are opening and it's the real deal and this is happening and we have a website and we got social media and we have a business plan and we have a couple angel investors or mom and dad or whoever is assisting in the initial investment or our own funds, and you could have a bank account with a little bit of money in there to get operations off the ground, I'm willing to pursue that because I yet have not had a case where they ask you for the net income and gross and net income of the company. They ask you on the form. We tell the truth, whatever it is. If you don't have a tax return yet, you do not have those numbers. You could put estimates, for example, but I always tell people put extremely realistic estimates. They're like, oh, Gil, this year I'm making much more money. I'm like, let's just stick to the numbers from last year. Because at the end of the day, that's not going to be the reason that a case is going to be approved or denied.
Not make or break.
I think it's more important that it looks like an actual operation. Like this is a real company. This is active. This is happening. I think that's more important for an 01, especially if they come back and ask any information about the company. If they do ask financial questions, it'd be nice to have, I guess, a bank account that has some money in it. So you could demonstrate a bank statement, maybe a statement from initial investors that they're going to be investing upon the visa being issued. Like there's certain guarantees in place. I think that's another way maybe that we could go about it. But yeah, if your friend also needs the 01, you could consider doing an 01 and an 02 and not having to do two separate 01s there, but that's up to you.
My only fear there is I don't want the 02 signing on behalf of the company.
We could get anybody that's authorized by the company to sign on behalf of the company. Generally speaking, what I advise in the 01 context is for people to have, quote unquote, a board of directors. These could be people elected by you to help you form a board and be able to make decisions on your company. These are not shareholders necessarily. These are not people that have a tax obligation. They just form part of the company. It could technically be anybody that you've designated for that company to be able to sign on your behalf. The reason Stephanie mentions that would be good to have a board or to have other people involved not being signed by that, because you technically cannot self-petition the 01 in the sense that you could sign your own paperwork. At least that's not how we do it.
Correct.
Like I'm sure there's people out there that do it that way. I'm very hesitant because that looks to me a little suspicious. They asked the question on the I-129, do you have an interest, a financial interest in this company? Are you a shareholder or are you an owner? And we say, yes, I own 50% of the business. Like that's absolutely the truth.
And mind you, I've done a situation where the 01 owns 50% and the 02 owns the other 50%, and it's worked out. It's fine. But I always have a third person signing on behalf of the company.
That's fine. That's fine. Okay. If you don't love that situation, do 101 first and then do the other 01.
Why?
So then one person signs for 101 and then the other one signs for the other.
That's what I'm trying to avoid.
Yeah,
I
would say,
love
I mean,
that.
no, I don't like it either, but it's
I
like
don't love that.
technically it's still fine because they're an
Yes.
officer of the company and they could sign on behalf of the company. So
Yes. I don't know what this guy's saying.
Stephanie, don't let me down.
On what? I don't
You know what I
let me down
mean?
on.
Hey, he's trying to raise you up.
I won't let you
He's
down.
he's inspiring you. He's like, don't let me down.
He says, why if I applied as Italian for a visa, now I have to wait because I'm Venezuelan? It's not fair.
I know, man.
You're preaching to the choir right here. Believe
Yeah.
me. And besides, you know why it's really unfair? Because a principal concept in immigration is the country of chargeability. And imagine being the country of chargeability, being chargeable, your country of birth, to Italy, and then just because you also have a Venezuelan passport.
Talk about that. So
screwed.
basically, chargeability, that's a term with immigration where, immigrant visas,
Yeah.
with immigrant visas. So you're charged to your country of birth,
Mhm.
regardless of the other 5 nationalities that you may have.
Exactly.
Okay.
But suddenly the proclamation
yes,
takes in
chargeability,
throws chargeability out the window.
they're like gone.
That's what's unfair to me personally. Like
That
at
is
least stick
unfair.
to it. You get it?
Yeah.
Like
Yeah.
at least stick to what
I
immigration law
understand the
is.
situation that
Yeah.
he's born in Venezuela.
Right.
If he's born in Venezuela, you're
And your
like,
country
okay,
of chargeability, I understand.
got it. I understand. That makes a lot of sense. But I'm a dual national and I lived in Italy for the last 25 years. Dude.
Yeah.
Yeah.
Like I have one that's I think, is Lebanon on the list?
I thought they were.
I might be making that up.
It's right here.
It was one, basically it was the opposite. It was not his country of chargeability.
I think they have limited. Let me see. Oh no, they're not on here. Lebanon is not on there.
Bueno, I had one and now I can't remember which one it was, but
Wait.
basically it was that.
Poor Lebanese man.
I know. I felt so bad for him.
You're
I was like,
guys, that's
the show?
the English show, man. It's the English show.
That's
We
the
got
show.
Cruz with us. Hello to the best ones. Hello, always here to learn. Thank you, Cruz. We got to get Alexis on. Every time I see Cruz, I think about Alexis. I'm waiting for you guys to come back to Colombia. We want to go back to Colombia. Stephanie was saying she wants to go to Medellin.
Really?
She wants to be in Medellin.
See, I tell Gil it's because I want to get business, but mostly I just want to go to Colombia
and
and get
she
some
wants to eat.
coffee
She
and
wants to
pan. I
eat.
love that you already knew where I
She
was
wants
going
to
with that.
eat.
I want to go to pan de bono, a little sancochito. But no, we hope to be there this year and be able to give consultations in person.
Yeah. Edgar, just so Edgar knows, good afternoon. Have you success responding RFE saying TPS doesn't allow change of status? We have in the past multiple times. Unfortunately, now with the pause, Edgar, we don't know what's up with those cases that we've argued that in the last, 30 days or so. So I don't have new information on that one. Hopefully, I would love, Stephanie, for USCIS to just come with a little guidance. There was a time that they had directors of USCIS, which would issue guidances on a regular basis for things that were very confusing with immigration law. They would create what's called memos. Okay. So there's a very, very well-known gentleman called Neufeld. And the Neufeld memo is still
Stunning piece of work.
I tell it's still phenomenal. It's about, 40, 50 pages. It's about adjustment of status and it has incredible. It's still active law. I believe it's 2008 memo, 2009 memo. That was a memo reconfirming a previous memo that was done, 2004 or 5. Neufeld memo is how they used to handle things. And they would come out with a great policy clarification on this is how USCIS is interpreting the law and this is what they're applying. They need to come out with that with TPS and just have a one-pager little fact sheet that says, listen, this is the law that allows it, or this is the argument against it. Right. Okay. And this is our position, whatever it is. But unfortunately, there's a lot of people in limbo because this is the truth. If you were never able to do a change of status from a TPS, then we just wouldn't do it.
Correct.
But the law is extremely clear. Extremely clear on it.
Currently. And already so many people have been approved under it.
And so many people have been approved. So we're just of the opinion, Edgar, I'm sorry that you're going through that, man. Larry, thank you, Larry. You guys are the best. Steph, thank you, Cruz, always being with us.
See you on Thursday for the Spanish show at noon. Nos vemos el jueves a las 12.
You speak Spanish?
I do. Do you?
No bueno.